make life easier.
Okay, you're on.
Good evening, ladies and gentlemen. Welcome to our May Indivisible meeting. Thank you for braving the weather to be out with us. Our keynote speaker is on his way. He will be here momentarily, but we wanted to go on and get some housekeeping things out of the way before he gets here. So without further ado, our announcements are.
So I've got a couple announcements, and feel free to correct me or add additional information from the audience as necessary. So on the 19th of this month, the Mighty Oaks postcard writing event is going to be this on the 19th. It's actually every Sunday. Sac County Democratic Headquarters. And if you have any more questions about that, there's information on the website. So that's happening on the 19th and the 26th of this month. And then on the 29th, the lobby day. So State Strong, California State Strong is having their lobby day, and we are going to join them there at the Capitol to lobby on the bills that State Strong has chosen. On June 9th, the Pride Parade, Sacramento Pride Parade is happening, and we are invited to march with the Sacramento United Methodist Church, the one on J Street.
No.
Nope, sorry.
It's all right.
Thank you for the correction.
We're invited to march with the Equality California, which is a lobbying group for LGBTQ issues. And we were lucky last year to have someone come and talk to us last year about a lot of the legislation. So in the back on the windowsill, there's this little flyer if you want to grab one. The parade is on Sunday the 9th, and it starts at Southside Park this year. Normally they used to start at Crocker, but at the corner of T and 8th. So if you look for the Equality California contingent, march along with them.
Okay.
It's a fun and important event.
Yeah, super fun. I hope to make it myself.
You've given a date, but not a time.
It says
very
actually
good.
be there by 10:30. I believe they start marching at 11,
Right.
but 10:30. It also says bring sunscreen, drink lots of water, wear comfortable shoes, don't throw anything. It says that here.
No throwing stuff.
And don't get drunk.
Yeah,
It just says no alcohol.
The other thing to note is it's actually a 2-day festival this year. So it is Saturday and Sunday.
Oh.
So if you want to attend the festival, it's anytime after 11 on the Capitol Mall.
And that's on Saturday. It starts. The festival's on Saturday.
The festival ends is both days.
Oh, okay.
So you can get a 2-day pass for $15 online, and there's more information about how you can get those online on that little flyer.
On the flyer in the back, on the windowsill back.
Yep.
Okay.
But the march is on the 9th.
The march is
The
on
march is
Sunday
happening
the
on
9th.
Sunday the 9th. Correct.
And
And
then-
the time for that is 10:30 to meet for the march. So that's on June 9th. June 9th also there is a Callaway Canvas event happening, and you can find these lovely green flyers with all the information wonderfully coordinated by Julie here, and those are located in the left side of the room here on the little credenza thing back there. All kinds of stuff. Do you want to talk
Yeah.
about it at all, or? June
Yeah,
9th?
talk about it, because they
So
don't.
El Dorado County is starting the Callaway team effort once again. And so this is to try and get Democrats, midterm skippers, to come out and vote. And so their first event is on June 9th. Then they have one on July 21st, August 11th, September 15th, and then October 13th. So they're doing one a month for 5 months, kind of test it out. This time around, they are going to be doing a little bit differently. If you have a smartphone, you'll get on the PDI. It's an electronic polling data thing, and you will put your answers in there, and then it'll sync to the computer, so it's no longer a paper process.
Oh, that's cool.
So that will help this process a lot.
So
So there's
For anybody who doesn't remember what Callaway is about, you want to give a quick.
Callaway is about getting Democrats or left-leaning NPPs to get out and vote. They're the ones that vote on maybe presidential election years, but don't vote on others. They vote sporadically, and so they usually call them midterm skippers. But it's to get all of these people energized and to make a commitment on a card that they'll actually show up for the 2020 election and vote. So many of you I know have tried this. Again, it's in El Dorado this time. So far we're not doing it in Sacramento County like we did did last year. And I think they're working on maybe doing it in Placer as well as some other counties that are going to be in Congressional District 4 to try to get rid of McClintock. So, okay. So this gives you what it is and what you'll be doing. On the back, Shabir's put together this cute little pictorial. If you knock on 40 doors, that will yield you about 20 conversations. And 20 conversations gives you about 10 commitment cards. And some of these people will vote, but that one right here is what you will be responsible for getting that vote in that they wouldn't have voted in the past. And that's on the 2018 midterm statistics that they pulled from the canvassing that was done last year.
Very cool.
Okay, so all the information you need, back on the back.
One more little tidbit, I heard that half the people that they're planning to contact in El Dorado County are registered Dems who didn't vote in 2016.
Oh,
Really? How do that, but they didn't. And then the other half are NPPs that are likely to lean toward the voting Democrat.
I'm not sure how they know that they're leaning, but
It's a demographic analysis.
yeah.
What is NPP?
no party
No
preference.
party preference?
Julie or Cheryl, I seem to recall that if we could sign up, or I got regular notices from Callaway for the last midterms about when the next ones
you
is
can
there.
get on the website,
Yes.
it's here,
Okay.
and it's down here. And you can go into the website and sign up. Something that's being done differently this time than it was last, you had to sign up and then they'd send you the address for where you're gonna be right now. You go into RSVP, it tells you exactly where you're gonna be meeting up.
And all of this stuff is on our website. So if you go to indivisiblesacramento.com on events, all of the links, it's all there if you're interested.
Okay, great.
And then just two other items. Our next meeting will be featuring Speaker Kevin McCarty. So really awesome there. And then that's on the 19th of June. And then on the 30th, we have a text bank training. So, which is also all the information about that is on the website. It's a really easy way to do, it's an alternative to phone banking. It's a lot easier. I've done it. It's super, super awesome. You basically just sit there and you push a button. All of the content is pre-written. And it's just really easy to use and can reach a lot of people. So that's on the 30th, and again, all information on the website. So without further ado, I would, one last thing? Okay, one last thing.
Two quick announcements. In the back again, there's another flyer. There is a webinar, or not a webinar, but a seminar at in Lincoln on Tuesday, May 21st, and this is sponsored by State Treasurer Fiona Ma to talk about scams, money, and you. It's also hosted by Jackie Smith, who remember ran an assembly district last year against Kevin Kiley. The other one, if anybody's interested, Placer's Stonewall Democrat Club is holding a barbecue and a membership drive on May 23rd, the day after Harvey Milk's birthday. So if anybody's interested, again, the flyer's in the back.
All right, beloved. So the exciting thing about the work that we all do together is that we get out and be in the community. And when we get out and we're in the community, we meet other people who are in the fight, who are in the resistance. And sometimes you're just in a situation where you see somebody and you're like, kindred spirit, that's somebody who agrees with me. And we definitely want to hear more from that person. And that's exactly what happened with our keynote speaker this evening. Some of us were out in the community. We heard him speak and we said, we've got to get him. So be excited with me for our keynote. John Stoller is a criminal defense attorney, former civil rights attorney and community activist. He is a frequent guest speaker at UC Davis School of Law, McGeorge School of Law, and the Sacramento State University, covering topics such as police practices, criminal justice reform, and civil liberties. He also leads continuing education programs for other attorneys in subjects such as forensic evidence, scientific evidence, and trial strategy. He's here to discuss AB 392 and its collateral issues. Ladies and gentlemen, join me in welcoming John Stoller.
Folks, I'm just going to have to apologize. I do not think I have the correct cord to hook John's.
No.
It's in HD, and both of them.
Well, I made a presentation for you, but you can't see it. You can view it on my website. Well, maybe I can send it to you.
No. It's the wrong corner.
Do you have a VGA cable?
I'm gonna go ask facilities, but why don't you go ahead and get started?
Going to get started. Very good. All right, so I was asked to talk about AB 392, but then I heard you have Kevin McCarty's is coming, so maybe you'll be very prepared with excellent questions. What I was first going to do with you all is explain the current use of force law. So, use of force by police officers, just so we're all on the same page, what we're talking about today is, use of force by an officer in the field. It is a beast of both codification in the penal code and then as well as certain cases in California and Supreme Court law. So we'll start with the penal code, and if I had the presentation, it did would transition to that. You're looking at Penal Code 835A and then Penal Code 196 and 197. Penal Code 835A is a really vague statute, and all it does is explain that any peace officer who has reasonable cause to believe that someone is about to be arrested as committed an offense may use reasonable force to effect the arrest or to prevent the escape of the person, or to overcome any resistance by that person. A peace officer who makes or attempts to make an arrest need not retreat or desist, things like that. They don't have to leave the quarrel, and they won't be deemed an aggressor if they're using reasonable force to overcome the resistance. So why is this important? Well, it's important when people die in our communities, right? Because Penal Code 196 creates a special justification for homicide. Now, homicide is the unlawful killing of a human being, right? And if you, I, a civilian, does it, there's certain rules that apply to us, right? The prosecution has to prove malice. You've heard of that, implied malice, perhaps. Now, there are certain defenses to homicide. A homicide is justified when the law says, okay, it totally happened, and this totally would be homicide, but because of the state of the law, it's justified. That's different than saying it's excused. If someone's attacking me and I act out in self-defense and the reasonable situation lends itself towards me using deadly force, my homicide then is excused under the law. But the police get what the law calls a justification. This justification then shields them from civil liability, and then as well shields them from criminal prosecution, yes? So the current state of law in Penal Code 196 explains that we are so close with this presentation. Explains that homicide by a cop is justifiable in the following circumstances. One, where it is pursuant to judgment of a court, so a death warrant, right? In California, thanks to Governor Newsom, there aren't going to be death warrants for a while, but a death warrant is an order by a court to go kill someone. So a cop has to go do that, right? Number two, when necessarily committed in overcoming actual resistance to the execution of some legal process or the discharge of another legal duty. So it's very vague. Necessarily committed when engaged in their duties. Then number three, when necessarily committed in retaking felons who have escaped or running away and things like that, the fleeing felon rule. So what anchors police right now under the penal code is necessarily committed and then the reasonable force from that earlier penal code. The courts have interpreted this to say that, well, police officers get to, it is all based on the objective reasonable police officer standard. And that objective reasonable police officer standard is merely whatever that officer has in front of them, would a reasonable officer have done a similar thing? Or would it be a reasonable decision by the reasonable officer? So that's the current state of the law. Does anyone have questions on that before we move ahead?
When you
Yes.
said death warrant, what situation is that, like sentenced to death? Is
Yeah,
that it?
exactly.
Okay.
Yeah.
After a trial.
Yeah, after a trial,
Okay.
you've lost your trial, you've lost your habeas, you've taken it all the way up. California just doesn't just execute you because there still has to be process. There needs to be a warrant ordering the executive to do something. Yeah. And that's called a death warrant. Have we failed? That's okay.
Hey, we might be doing more, but
So how do we interpret all these? Again, it's reasonableness by the police. So one of the key decisions to be aware of with the current state of the law is Tennessee v. Gardner, which is ironically very much the Walter Scott case. We do remember Walter Scott. He's the gentleman who was fleeing from the maybe elderly overweight officer and then was fired on and shot in the back, right? The United States Supreme Court said, it is not better that all felony suspects die than that they escape. Where the suspect poses no immediate threat to the officer, no threat to others, the harm resulting from failing to apprehend him does not justify the use of deadly force. That was in 1985. So the Supreme Court clearly didn't want Walter Scott to die, right? But their current rules aren't doing enough. Then we have Graham v. Connor. Police really like Graham v. Connor. If you frequent any police blogs, such as Police One, they love Graham v. Connor. Graham v. Connor says, the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with the 20/20 vision of hindsight. So in Graham v. Connor, that was used to justify beating up a diabetic man. He claimed he was beat up. He really just had some pushes and shoves, and so the court kind of said, we don't really know what happened, but this isn't it. This isn't excessive force. Problem with that decision is lower courts ran with it and adopted much more sweeping language, comparing our streets to battlefields and things like that, saying we're not going to double check the police in these circumstances. And if this was up, then I would have the picture of Eric Gardner being choked. So what does AB 392 do, right? Well, AB 392, in my opinion, just kind of catches us up to what the Supreme Court wants in Tennessee v. Gardner and makes a few crucial changes. One of the key changes is it changes Penal Code 835. Remember, that's the really vague one that talks about reasonable force and just kind of leaves it at that. Well, the new Penal Code 835 will differentiate between all other reasonable force and reasonable deadly force. So it's drive a wedge between those two. And it'll keep the current paragraph about reasonable force, but it'll say reasonable force other than deadly force may be used to apprehend, yada, 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 the rest of the definition. And then it'll define deadly force as that force which is likely to cause a substantial bodily injury on the suspect or lead to his or her death. And then it says deadly force will only be justified for where there are these three circumstances. One, the police already believe, well, we'll get to that. So where the defendant has acted towards death or substantial bodily injury is one of the circumstances. Two, to prevent the escape of a fleeing felon under new fleeing felon rules, and I'll get to those. And then three, there can be no deadly force where the threat is to the subject alone. So this is great for populations like Sacramento with many mentally ill in them. So if someone is saying, I'm going to kill myself, and is lashing out at themselves, a 5150 situation, I'm sure you've heard those terms before, police cannot use deadly force in that circumstance. So it's changing reasonable force by driving a wedge between the general definition, redefining deadly force, and then saying these are circumstances where it can be used. But then it has a little caveat, which I don't like too much, and it says this cannot be the standard for the prosecution of a police officer. So you won't see police officers prosecuted criminally based on these standards. Do you want my sarcastic answer, or do you want my real answer? You know, the sarcastic answer is that we're just going to expect police to be good actors, and that the reason they've been hurting people is because the law was vague. And that's why they were hurting people. The truthful answer is probably because that's how they're going to get this bill passed. And California, unlike many states, has a very prolific police lobbyist arm. Police don't like this bill. Things like this are the pill you have to put in there to make your bill survive. Yes, ma'am.
So can you walk us through that a little bit? Let's say that this is standard is in place.
Yes.
And a cop shoots somebody, and under what circumstances would it be adjudicated that this cop failed to abide by that standard of force? If it wasn't a criminal process, would it be a civil, like wrongful death suit?
Correct, yes. So that same paragraph says this cannot be the basis for standards for a criminal conviction. Doesn't insulate them from criminal liability. It just means if the DA is going to bring a case, they can't seek out like jury instructions saying, the officer was supposed to do these things, ladies and gentlemen of the jury. He didn't do these things, therefore you must convict. That's what that paragraph does. The next line in that same paragraph says that this can be the basis for a civil suit. So a plaintiff suing for wrongful death in that circumstance would get jury instructions saying, ladies and gentlemen of the jury, we've heard the case of John Doe v. police officer. The police officer had a defense to excessive force. One of the defenses was that it was reasonable. To find that it was reasonable, you must find such and such and such and such and such and such. Does that kind of make sense?
Yeah, although even in a criminal prosecution, would the prosecution still have some stronger case even without the jury instructions issue? Is there anything that helps?
For criminal prosecution,
Yeah.
no, not with the new statute, in my opinion. It will lead to more administrative penalties. If police agencies do adopt this as their model, you'll see officers get write-ups and things like that, and then you'll see some change there. Doing jury trials, I will tell you that the law is great when it's on your side, but more than anything, what controls a jury trial is the emotion of the jury. And laws like these being in the public eye changes the emotion of the jury, right? And if this is the law, whether or not the jury gets instructed about it, they'll think it's the law. You know, jurors do bring in their misconceptions with them into the jury room and then use them to decide cases. Whether or not that leads a prosecutor to change her mind about whether or not to prosecute is up for debate. So that's actually a good segue. So prosecutorial discretion, does anyone have any questions on that? I kind of just left that out there as an answer just now, but does anyone have questions about prosecutorial discretion? We kind of all understand it's up to her, right, or him, whoever happens to be in the county. The Attorney General under our state constitution does have the power to step in when he or she chooses, whenever he or she feels that the laws are not being fairly enforced. That would not happen. All right, so moving on. What are the other key changes of AB 392? Well, it creates conditions and definitions. One, it preserves an officer's right to self-defense. And if I was Kevin McCarty, the way I'd be selling this to law enforcement lobbyists is that this does not remove your boys in the field from acting in self-defense. They still get to act in self-defense where it's reasonable. All this does is change the rules of engagement, such that when you're apprehending a fleeing felon, you have to abide by the new deadly force rules. And these are them. The officer reasonably believes use of force, of deadly force, is necessary to prevent the escape of the fleeing felon, and all of these conditions. One, that felon, so not a misdemeanor, not someone that's like knocked off a Walmart and is running off. You can't draw your gun on him anymore. It's a felon involving deadly force or substantial bodily injury, either the use of it or threatening it. So before, if an officer reasonably believed if this lovely young woman here knocked off a Walmart and I'm a police officer and she goes running after me, I get to draw my weapon if I think it's reasonable, aim it at her back and not say anything. I don't have to say anything under the law right now, and try to apprehend her that way, if a reasonable officer feels it's necessary. The new rules will say, I can't even draw my gun. Because in my opinion as a lawyer, drawing a gun is use of deadly force. You don't draw a gun unless you're prepared to use it. So, number one, felon that was involved or threatened the use of threatened death or substantial bodily injury. So this is the felon who has beaten his wife, thrown her down the stairs, she's unconscious and fleeing. Deadly force is okay.
And he's a convicted felon?
No, thank you. I am saying felon just to make it clear.
Okay.
He is not accused of anything. It must be that what is suspected of him is a felony, not a misdemeanor. If they suspect a misdemeanor, cannot draw the weapon and engage in this. Number two, the officer must also believe that unless they apprehend that suspected, felon, that the person will engage in an action that will lead to future death or substantial bodily injury. So if there's no reason to believe, like example of this would be someone that steals a car and almost hits somebody, jumps out the car and runs away. Let's make it a really nice car so we know it's a felony, right? Because right now, really bad cars can be misdemeanors if they're stolen. People be Page, it's a case. So I steal your Mercedes-Benz, I almost hit somebody, maybe I run over their foot even while they were crossing the street. Well, I kind of got to substantial bodily injury there, I've committed a felony, but there's no reason to believe I'm going to cause future death or future substantial bodily injury, right? My crime is over, I've done my crime, now I'm just kind of fleeing. Now, if in that same circumstance I have a gun and I'm firing wildly back at the police officers who are chasing me, well, that's pretty good evidence to think that I might hurt somebody unless I'm apprehended. Do we see the distinction?
Yeah.
And then finally, the third one is before using deadly force, the officer must identify themselves and let the suspect know that they're going to engage in the use of deadly force, if feasible and safe. So, I mean, I don't know when it's ever unsafe to really say, I'm a cop, put your hands up, but there is that condition there that they don't always have to identify themselves, but they really definitely should. So any questions on the new use of force paradigm under Assembly Bill 392? Yes?
Just one. If the person who's stolen the nice car is run over somebody's foot and keeps on, in that vehicle, is it legit for the police officer to assume that he's going to run down somebody else?
Maybe. That would be a jury question later, but yeah, maybe. It's a tough call. Yes?
But that sort of sounds like speculation, like number one, talked about the felon has to be, gonna exert force. Like, so isn't that like, what, you know what I mean? Like if he's running away, he's not doing that.
Right. So, like, there's a continuum, right, of what becomes reasonable. There's like on one end where that's just pure speculation, where you're grabbing facts out of nowhere. And then there's on the other side of the continuum of, we don't really have a doubt that this thing is going to happen. There's no reasonable doubt. Courts and cops, judges and juries deal with these things all the time. And when we're putting it into this paradigm, it becomes really difficult, and it's easy to see, well, maybe there won't be any change at all. And that's something I'll get to in my next slides. But first, some more questions. Yes?
This cop that has now pulled a weapon and said, I'm a cop, stop.
Yes.
Does he have a camera?
Depends your jurisdiction. And depends your jurisdiction if he turned it off. Yes,
that was the next question.
Oh.
It's like, oh yes, I did, but.
it wasn't working right there. Yes.
You might be getting into this later, but this seems like it would have a backward effect on training. Like you need to train officers, if nothing else.
Mm-hmm.
That seems like one potentially could.
That's an excellent point, and it goes much deeper than you may have intended. That's one of the things the police lobbies are arguing about. They're saying you can't roll this out right away because we're not trained yet, and you're going to cause all this civil liability for our counties and our cities, because we're going to wind up getting sued because our cops are trained such and such way. Well, we just compared the old law to these new laws, and we look at Tennessee v. Garner, right, that said it's okay for the bad guy to get away, you can't shoot people. I don't think it's a good faith argument to say I was training my people to shoot misdemeanants who were running away from Walmart. If you like really think about the argument, it's like, well, what are you saying? You're saying like right now you've been shooting people, and like you're totally, and that's how you train people? Because I guarantee in the lawsuits you said that's not how you train people, right? Because the way you defend these lawsuits is you say, no, we train them very well, and like this would never happen under the training. So it's a catch-22, but they are using that exact same argument. Another reason why that argument goes deeper is because law enforcement is going to want money for that training. Right? And they're going to say, I'm Sacramento Police Department. I have 500 sworn officers. 400 of them need to be trained at the new paradigm. Who's going to pay for that? Who's going to pay to put part-time staff out, right, when I have to take those officers off the street, put in trained officers in while they're supposed to be doing their things, or if they're doing on their break time, who's going to pay their overtime? Well, when you get into a state law ordering counties and cities to do something, you risk getting into what's called a state mandate. A state mandate then requires funding where the county and city can turn around, and it's not a lawsuit, but you go to the Commission of State Mandates ran by California and you present what's called a test case, and you go to the commission and say, give me some money. And then this bill could turn out to be very expensive, long story short. Yes?
Are you going to touch on SB 230?
I had not intended to, but I can.
Yeah, I think there's monies included in that legislation.
I'm pretty sure it's state mandate money, yes. Yeah. They specifically say this gets money.
Yeah. That's the training one, is that the like
That's by the sheriff.
Yeah. But it doesn't do anything. Yeah. So it's like money, but you don't have to do anything. Right. So that's why the police like that one.
And it doesn't become effective unless 392 passes.
Right.
Exactly.
Yeah.
Well, so, but I had not intended it. And again, so we just looked at Tennessee v. Garner and stuff, and so facially, everything I've explained seems kind of in line with what the law was before, except for the next section of 392, where it defines necessary. And that I think is the sea change. It says this, necessary is this, where an objectively reasonable police officer in the same situation would conclude that there was no reasonable alternative to the use of deadly force that would prevent death or serious bodily injury. Right?
Cell phone, or like, I mean.
Well, no. So if a reasonable officer would believe that the glint of light is actually a firearm, I think that is still fine under this paradigm. What it is more like is like the Philando Castile shooting, right? Where the guy's reaching for some identification, right? In the paradigm now, was that reasonable force? Was it reasonable to think that this guy was reaching for a firearm? Now the analysis would be, is there no reasonable alternative that would prevent death or serious bodily injury? So anything that could cause paralysis or removal of the felon from the firearm or whatever have you is a reasonable alternative that would stop death or serious bodily injury, right? Because it's up to that level. If there's reasonable alternatives that would still have within them a smaller crime, you still have to do it. You kind of see my point? like reasonable alternative, but if the cop engaged in it, he'd wind up with some bruises. Right? The new standard says they have to do it that way. Does that make sense? So, example like that would be a bunch of control holds and like physically rustling with the suspect, right? Instead of using deadly force. And then I have a picture of, so that was AB 392. I was next going to talk about Mueller in Congress because I was asked to talk about that. But before we wrap that up, are there any questions? Yes, sir.
So, mentioning 230 again.
Yes.
Is there any conflicts between the two pieces of legislation?
Conflicts? No.
No.
No. Yes.
And this is what, just knowing about 230, only what I read in D, it seems to me that something quite remarkable happened to SB 230 in the committee hearing.
Mm-hmm.
And it went in having conflicts. The 392, and it started out to be an alternative that someone could vote for and say that they had voted for reform without actually changing anything. And
That's slick.
to get out of committee, it got turned into something rather different. Do you know anything about how that happened?
How that happened, lobbying, is how it happened. I brought with me the most recent SB 230. You can take a look at it, and you'll see the changes they made on April 30th in that most recent committee. They deleted some of the most offensive parts of 230 to make it conform with 392. I think that was just wheeling and dealing between McCarty and Weber and Caballero. I think it was just, the law enforcement did their gambit, did a power move when AB 392 first came, where they came and they filled the top ranks with a bunch of on-duty police officers all dressed up, so we paid for that. And then they sat up there to intimidate people. But then Black Lives Matter and the ACLU also filled it up at the bottom.
Yeah.
And, that from groups like Indivisible, really inspired the lawmakers, and for once they weren't intimidated by the law enforcement lobby. So they kind of doubled down, so now is the moment, got Caballero on their side, and I think that was what was remarkable, was the grassroots effort by local organizations, getting people there to let our leaders know that we support what they're doing. Sorry, she had her hand up first in the back.
This is maybe tangentially related, but staying local, we learned from a speaker and also from local news that following the protest in the Fab 40s where there was the kettling and all the arrests, that the police were negotiating with reporters about what they were proposing as a new policy, that they would have the authority to remove the press to a safe location, a safe distance from protests.
Yeah.
And, our jaws were on the floor, and as last we heard, that was in negotiation or discussion. Just wondering if you've heard anything about that.
I haven't heard anything about that. If the SACB wants to make an agreement with law enforcement, where the SACB and law enforcement say that, well, SACB people aren't going to get arrested so long as they are 500 feet away, that's between them. Whatever they want to do. I'm kind of disappointed that the SACB wouldn't go in and then get further information, like of the protests, ground level protesting, talk to the protesters, right? But do you see kind of my point? I see the fault is more in line with our media than.
So the impression we got was that they weren't happy with it, that this was something.
They weren't accepting.
Well, that's
yeah.
good.
Without, but
Yeah.
I just was wondering if you'd heard anything on what the upshot was.
Oh, I haven't heard anything about it. My answer kind of looks at it from a constitutional paradigm. Like, I don't see that as a problem. You could maybe argue it's a prior restraint on speech because it's preventing media people from going in and accessing parts of the protest. I'd like to see how it plays out. And that's what I was getting at, if the media is actually going to accept that type of condition. Right.
The
Kat?
paper
I just wanted to point out that SB 230 did have a different use of force
It did.
model.
It was
which
deleted.
They deleted
Yeah.
because everybody showed up.
Right. It said, and that's why I brought this here. It said,
It basically said, let's just keep things the way they are.
yeah, it just regurgitates it in paragraph 2. Yes, ma'am.
It's important to remember that the SACB is owned by McClatchy. And that's kind of important because he's a major supporter of Trump.
It's kind of like them trying to remove anybody who's involved with the press.
Right.
That's the goal.
Right, no, that is the goal. And that, I think, is unconstitutional, removing the press from the program.
Maybe.
Yeah.
Maybe.
Maybe? Yes, ma'am.
Apologies to the group that's been more engaged with this bill. I'm just at the beginning. It sounds to me like it's better than nothing in terms of reform, the use of force.
It's a start.
Would you say that's better than nothing?
Oh, yeah, I think as written, it can become very powerful. What will hamper it will be the fact that no criminal prosecutions would come out of it. And even if criminal prosecutions could come out of it, we'd be relying on district attorneys to make that decision. Right? Because even when all the elements of a crime are ticked off, there's nothing that mandates prosecution. Rape is a great example of this. You look across counties and you see wide-ranging different investigations and prosecutions of rape. I do not think geography alone accounts for that big difference. Just my opinion. The other thing that would hamper it is how well do we see a pushback when it comes to governmental immunity in the civil cases, right? Already getting a civil case going is very difficult. You need actual damages. Well, if a guy only had a gun pointed at him, right, and he's a homeless guy like Joseph Mann or something like that, what are the damages? Are you going to bring a lawsuit? Are you going to be able to get a lawyer to help you? These things will still hamper progress. But AB 392, I commend Kevin McCarty for making it. It is an excellent start, and it is needed reform, and it could save lives in the field. And that's the most important thing, is just saving lives of people. Like, there's holding people responsible, but then there's also not dying anymore. So let's talk about Mueller in Congress real quick. Do I have time? It's 7:52.
Yeah.
A few minutes. All right, I want people to see this picture because I found this on there and I can't stop unseeing it. So I'm just going to walk this around. Does anyone remember the show, Dinosaurs? Yeah. Son, one of those mountain model babies. That's pretty good. That guy.
That's all right.
So let's talk about congressional subpoena power. Well, it is codified in the U.S. Code. Right now you're seeing a lot of pundits argue that Congress doesn't have any teeth and they can't do anything. Well, the U.S. Code does say that refusal to comply with a subpoena order from Congress is a misdemeanor. That's 2 U.S. Code 192. To enforce it, Congress, however, would need to rely on some type of federal executive, ideally the D.C. Attorney General could go enforce it. Right? Not Barr himself, but D.C. as in like the territorial area where they use federal prosecutors for everything. But outside of that, what is the history of subpoena power? Well, it's been long recognized as inherent to Congress itself. And this really should come as no surprise for a country that went through the Red Scare and with the House Committee on Un-American Activities, the HUAC. And the court has long upheld subpoena power, so I'm really surprised to see so many pundits arguing it doesn't even exist. In Watkins v. United States, the Supreme Court explained that they start with the basic premise that Congress needs to investigate stuff to create laws. It's a necessary part of the various clauses of what they have to accomplish. And that in Watkins v. United States, it included a probe into departments of the federal government to expose corruption, inefficiency, and waste. So I hesitate to believe that there's no subpoena power when the Supreme Court, in a near identical circumstance, has already said it exists. Another case to be aware of is Eastland v. United States Servicemen's Fund. There, the Supreme Court used the speech and debate clause to enforce a congressional subpoena that was targeted at a potentially fraudulent nonprofit. So basically, Wounded Warriors of the 70s was going around. Some of you might remember this. They used to have the bakeries and the coffee shops right next. Really kind of profiteering off of soldiers. And so Congress wanted to look into that, and they did, and they sent subpoenas. And there are all the same arguments about those subpoenas that there are about these subpoenas, saying, oh, they're going to lapse, they're not going to exist after the next Congress and things like that. Courts said no. Congress has power and the legitimate interest in investigating subversive elements of laws that they have to enforce. And that it was the duty to create an army. And then Nixon v. Administration of General Services. Some of you might remember there was a new administration of General Services that was created to get all the Watergate tapes. Nixon sued him. And then said, executive privilege, you don't get anything, redaction, redaction, redaction. Supreme Court said executive privilege is not a blank check. You gotta tell us exactly what it is, what you're doing, and then we'll tell you if it's privileged, and then it'll go out in response to the subpoena. So all those same arguments you're seeing in the media from right-wing pundits, the Supreme Court has already definitely dealt with them. And then there's a case from 1821 that I quite like. It's Anderson v. Dunn. When he gets in time, go look it up. So basically, this guy, Anderson, was the brother of an attorney general, and he was doing some Donnie Trump Jr. stuff, right? He's committing some fraud. He's going out there, making his money, doing his thing 200 years ago. And they subpoenaed him to come to a committee hearing. He didn't come. And so they sent their sergeant at arms. And back then it was a real sergeant at arms. And sergeant at arms marched across state lines, arrested him, and hauled him into court, and hauled him into Congress, and they did their hearing. Well, the guy turned around and sued the sergeant at arms for trespass, assault, battery, kidnap, and all these things. Case went all the way to Supreme Court. Supreme Court basically just kicked out the lawsuit and said that Congress has an implied necessary power to penalize people who are not members for contempt of Congress. And it's part of the necessary and proper clause in the U.S. Constitution, Article 1, Section 8, Clause 18, that in order to do these things, they need subpoena power, they need to be able to enforce it on people even beyond the Congress itself. Yes, ma'am?
So how does that apply with Trump using executive power over McGahn?
Well, executive over McGahn,
Saying that he can't testify?
I mean, oh, so you're asking me if that's obstruction? I mean, yeah, it's obstruction. And I think if Barr were here, he'd say obstruction. I think he would just say that it's not worthwhile. If you got that guy to answer honestly, what he would say, fine, fine, fine. It's obstruction. All the elements are met. I don't think it worthwhile because there's no actual underlying crime, is what he would say. Now,
That doesn't hold water.
humans can disagree about that. I don't know if reasonable minds can disagree about it, but humans can disagree about that. I often think that the cover-up is worse than the crime in most circumstances. I think many of you would agree with that. I'm just trying to stay apolitical in my answer. Yes?
If they decide to start impeachment processes, is that going to affect whether all this ends up in the Supreme Court, these subpoenas? Does that affect anything, either in terms of the timeline that they end up in the Supreme Court, or just whether we can avoid the Supreme Court if we start impeachment process? Do you know if that makes a big difference?
Yeah, good question. So the way that the Trump administration would have to fight the subpoena power is they're going to need to seek an injunction from a federal court of competent jurisdiction. Hearing what I've heard about Trump, he'll probably try to file it straight in the Supreme Court, but he has plenty of his buddies on the federal bench too. He did a great job stacking the federal bench. So You know, they'll just seek. It'll probably be in D.C. where his sister sits.
No more, she retired because she was.
What's that? Oh, she retired? You guys are more informed.
She died.
She was forced to retire by
They
the
started investigating Trump.
because she was found to be cheating her on taxes.
Yeah.
Probably with the Deutsche Bank.
They're going to begin an ethics.
Yeah.
Were they?
Yeah, so that she
Oh, I have
retired.
no idea. I don't watch
2
the
weeks
news
ago.
that much.
Maybe
2 weeks ago.
Yeah, you're probably thinking of that. Much deserved.
So, to answer your question though, they got to start an injunction in a court of competent jurisdiction. It would start with the district court, the lowest level federal court, and work its way up through a court of appeal and eventually to the Supreme Court.
Okay.
Yes.
So, back to the sergeant at arms. For those of us who would like give a kidney to see somebody it seems like the Democrats or the media or whatever is treating it as this just outlier of a possibility, and it's crazy talk. There's this little room that's like a broom closet in Congress where you'd have to sweep up before they put anybody in there, and I get this image of this creaky old, Gomer Pyle sergeant at arms. But is it a real possibility?
Yeah, they have the power. In my opinion, they have the power, and in my opinion, they have the power to deputize someone to do it. They don't need to rely on Gomer Pyle. I think you could deputize. It could be you.
I vote for Jill.
You'd never be so lucky.
He'd never get out.
But the distinction, though, that I think that you need to pay attention to when you hear these arguments is what are they actually talking about? Are they talking about inherent congressional authority that Congress just has by nature of being a government? Or are they talking about the codified powers in the U.S. Code?
Okay.
And the media's go play games in what they're talking about when it comes to this, I think. Not that, when I say media, I mean like Fox and the pundits and all the people that come on television and Barr himself, right? Like, I'm including everyone in there. They're going to play a lot of games. When they say, oh, that's not in the law. Well, in one turn of phrase, they're going to mean that's not in the U.S. Code. And a congressional prison is not in the U.S. Code. That's absolutely right. But the opinions talking about inherent congressional power reaches back into common law, which existed long before the U.S. Code ever did. And it gets its tenets back from like King George, right? And from when we first adopted English common law as our group of laws for the kind of northeastern colonies, and this is how we were doing things. And it's reaching back into that as like what's philosophically driving it. And part of governmental theory in this group of law is this inherent power of Congress to penalize someone. So when they say it's not written in the law, they're right. But it's been long recognized to be a power of Congress.
So it's a precedent which, if you're a strict constructionalist, right, you would presumably uphold that because that is your, philosophy of life, right, or law.
Textualists manage to make words mean things that I don't even understand. It is not in the Constitution. Here's how I'll answer that. It is not in the Constitution that Congress gets to do that. The Supreme Court had to read it into the Constitution that you get to do that by relying on the philosophies of English common law. Does that make sense? Now, a conservative court could turn around and say that court in 1821 was an activist court, and we hate activist court, and they created this thing. It's not a real thing. We have our Constitution that is not a constitutional power. So, right, with literalists, I don't know, right? But if we're going with original intent, with what the framers had sergeant at arms that went and arrested people. We know that because in 1821, just 50 years after the thing was created, they were out there doing it.
I like it.
So, any other questions? Kat?
Well, not a question, but a comment. The right wing says, well, there was no collusion, blah, 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 so you're trying to subpoena people, and all of this is, water under the bridge, forget it. But the investigation of corruption and all that also goes, the implied power goes, to considering what laws might be you know, be appropriate to handle a situation like this, and therefore it's relevant not just to get somebody, but to obtain information about how to protect the public in general.
That is exactly right. If we are going to update our basically federal political rules, and so far, that's not my area of law. I don't know much about fair political politics and all that. But if that's going to be updated, Congress needs to know how the nefarious actors are operating in order to make up rules that prohibits them from acting nefariously. The only way they do that is by asking the people that know the nefarious information, which are sometimes the people investigating and sometimes the criminals themselves.
The
Right?
Collins of the world, right?
Right. So you need to be able to investigate and to write good laws. And that's exactly what Watkins v. United States says, is that necessary part of the legislative process in being a Congress is investigating what the right law is going to be. It's a great comment. Spot on. Yes, sir.
Just one last question. I love my TV pundits, but I've heard that one pundit say that if impeachment hearings start, then they can act as a grand jury, giving them more power. I don't see how that actually fits. Is that?
This doesn't make any sense.
Well, more power in the sense of when they issue subpoenas, it need not be for a legislative purpose. Because
they can do that now, right?
they can issue subpoenas, but in all the cases talking about it, there was generally some type of legislative purpose going on. So I don't know exactly what this pundit said, but if I were to guess based off of what you're saying, that would be the distinction that he's going to die on. All right, well, thank you for your time, everyone.
I hope you all can see why we heard him and saw him and said, he's one of us. And bring him in. So let's give our John Stoller our keynote. Please don't forget to take flyers on your way out. Are there any other announcements for the good of the order?
Very quickly, a big thank you to everyone in April when we were having that matching fund drive. We got the maximum amount, so we got an extra $500 as matching funds from individual matching funds. You guys were very generous. Thank you so much.
Very good.
All right. Thank you so much. We're adjourned.
All right.
See you
Thank you.
next month.